All right. Good afternoon, everyone. Welcome. Thank you for joining us for today's webinar series presentation, Routine to Rare Scenarios. We're going to cover conditional payments A to Z. I am really happy to welcome you today. This is the first webinar where we haven't had our esteemed founder, Heather Sanderson, on. She has entrusted myself and Kayla to do the presentation here today. So welcome to you all. We'll go ahead and get started. My name is Annie Davidson. I'm one of the attorneys here at Sanderson Firm, and I've been in the industry myself for quite some time. I spent almost a decade with a different vendor in this space, and then prior to that, I was in private practice in Minnesota, which is where I'm licensed to practice law. I handled work comp insurance and liability insurance defense cases for a mid-sized firm. So that's really kind of how I entered into the Medicare industry and kind of became a Medicare nerd. I will turn it over to Kayla Pigeon to introduce herself, and then we'll get moving through the slides here. Kayla?
Hi, thank you, Annie. Good afternoon, everyone. My name is Kayla Pigeon. I am the AVP of MSP Compliance here at Sanderson Firm. I'm creeping up on a decade in the Medicare Secondary Payer space. I started internally at a large carrier, spent some time in the Medicare set-aside side of the house, moved over to conditional payments, handled everything from workers' compensation, no-fault, and liability insurance scenarios.
Awesome. Thanks, Kayla. Yeah, wealth of resources, right? Wealth of knowledge working at a carrier, especially a large carrier like you are involved in. For those of you for whom this might be your first webinar with us, just a little bit about us. And Sanderson Firm, like I said, we were founded by Heather Sanderson. She has been in the industry quite some time as well. And we provide unmatched, innovative Medicare secondary payer expertise. That's what you're coming to us for. We are a boutique law firm. We offer our services all across the country in terms of all areas of Medicare secondary payer compliance. So that's your Section 111 compliance, that's the mandatory insurer reporting, your Medicare set-asides, and then conditional payments. We are proud to be women-owned. We have that national footprint. We've got a boatload of legal, clinical, and claims professionals with over 500 years of combined experience. We just hit over 50 employees. By the beginning of June, we'll be at something like pretty close to 55 employees. So if you've been watching Heather and the trajectory here, we're just coming up on 5 years of being in business and just moving and shaking all over the place. So we're happy that you're with us. We will dive right into our agenda. We're going to cover some recent developments and a quick level set in this arena. Again, we're focusing on conditional payments, largely in the workers' compensation space, but we do have some topics on liability and no fault because both Kayla and I have extensive experience working in those areas. I originally cut my teeth when it comes to conditional payments in private practice, so it's been quite some time. We will cover, we'll talk a little bit about the different recovery contractors that Medicare uses for their traditional Medicare conditional payment actions. And then we'll talk about those traditional disputes and appeals. We'll talk about the Department of Treasury. Built in within these, we go through the scenarios, right? We promised you some scenarios. We're going to talk through those scenarios from routine to rare. So they're built in along the way. Then we'll kind of button things up with the Medicare Advantage recovery and how to handle that, because that is a whole different ball of wax than the traditional piece. And then we'll send you on your way with a little bit of takeaways and a wrap up. So feel free to throw your questions in the Q&A, and we will try to keep an eye on that. Otherwise, we will take questions at the end. Use that Q&A feature, not necessarily the chat. We'll check the chat as well, but try to use that formal Q&A process. Okay, with that, we will dive right into the recent developments and our level set. In terms of a level set, when we talk about Section 111 reporting and recovery, they kind of go hand in hand in Medicare's world. They release, they publish an annual kind of memo letting folks know that there's a threshold for which they will want you to report something and for which they will go back and try to recover. The threshold has been for, gosh, almost a decade. It's probably 8 or 9 years. The threshold has been $750. Before that, it was $1,000. So December 16th, 2024, Medicare did publish their notice for 2025. The threshold remains $750. So what does that mean? That means that Medicare and Medicare Advantage plans cannot seek recovery if you settle out a claim for $750 or less. You also don't need to do the Section 111 mandatory insurer reporting if you work for a responsible reporting entity or handle their claims. So that remains in effect. We just wanted to make sure to highlight that. So always keep that in mind. It's pretty rare to settle cases for $750, but it does happen, or less, right? If you think of big box retailers, maybe offering a gift card, sometimes those can register and kind of take care of a situation for someone, so you don't have to worry about it. All right. Then in terms of kind of just a recent update, there was actually some case law here very recently out of Illinois. January 17th, we had a decision come out of the Northern District of Illinois. It's the Illinois Insurance Guarantee Fund versus the FARA, which was the acting HHS administrator when they brought this case. If you've been in this space for a while, you may be familiar with SIGA versus Burwell, and there's a few other insurance guarantee cases across the country. The kind of, to steal my own thunder and not walk through all of these bullet points, realistically, this means that this insurance guarantee is getting the same treatment that California insurance guarantee is getting in Illinois. So when we've seen these cases be decided around the country, they're really sort of falling in lockstep and finding that the guarantee funds and associations are nonprofit organizations or other entities created by statute, right? These are safety net organizations for when a carrier goes out of business. And in this case, the beneficiary suffered a workplace injury. Medicare did try to get those conditional payments back, but the carrier became insolvent. And so the guarantee fund gets involved and they're not a primary payer. That's the crux of this. So it's consistent with SIGA versus Burwell. There's the Rhode Island case. So you'll see this behavior throughout the country, and even some insurance guarantee funds who haven't yet had cases are behaving in a manner where they're not reimbursing conditional payments in certain situations. So you want to keep an eye on it. I do believe Medicare did at one point issue some guidance around this. And I don't know that they ever put it anywhere, super formal in writing, otherwise we would put that up in front of you. But if you have questions about it, certainly let me or Kayla know. We're happy to answer questions about it. I certainly have seen this come up in Minnesota with the insurance guarantee here. So it does come up from time to time. But that's kind of our quick, updates. And then we'll move into the level set here. I'll turn it over to Kayla. Kayla, do you want to talk us through kind of the overview of conditional payments?
Yeah. So let's just kind of reground ourselves in what even is a conditional payment. What are we talking about when we're talking about conditional payments? So a conditional payment really is when Medicare has made a payment for Medicare covered treatment for which they believe there's another primary payer. Most commonly, we think about this, or maybe the easiest example to think about is an individual suffers an injury while at work. Let's say they broke their arm. They're headed to the emergency room to get treatment, or they're continuing to have treatment after the fact. Basically, what will happen is Medicare agrees that they will pay for that treatment on the condition that they have the ability to recover that payment if there is another payer that should be responsible in that scenario. In that scenario, a workers' compensation carrier. Really, the idea behind this is not holding up care. We're not looking at coordination of benefits issues when we're in an emergency room or when we're looking at an individual trying to continue their care. Conditional payments, we think about both with traditional Medicare, parts A and B, but also now with the Medicare Advantage plans as well. We're going to talk a lot more about Medicare Advantage plans later on in the slides, but just know those Medicare Part C and D plans also have this right to recover their conditional payments. Why are conditional payments important? What makes it important to understand and proactively identify and resolve conditional payments? There's really two abilities that Medicare and Medicare Advantage plans have that mean that we really want to pay attention to this. The first is they have what we call a priority right of recovery. This means that regardless of your settlement language, they can actually recover conditional payments from any party to the settlement. So if they've issued payments conditionally, there's a settlement, they can choose to recover from the insurance carrier, from the claimant, or from the claimant's attorney, any party to that settlement. So they have that sort of extra ability to do that. In addition, they also have this ability to recover double damages. So if for whatever reason those conditional payments are not handled timely, they're not reimbursed, after 60 days, Medicare actually has this ability to file litigation. And if they have to do that and pursue that litigation to recover their conditional payments, they can recover double damages. So you can imagine if we're talking about very large conditional payment liens, this can mean very large payments that are having to be made, whether it's by the carrier, even by the claimant attorney in some scenarios. So this is why we always recommend that conditional payments be proactively handled and looked at within the settlement, and we're not just leaving things for other people to handle. Conditional payments are also extremely time sensitive. So we want to pay attention to when we're getting conditional payment letters, whether or not they have dispute or appeal deadlines attached to them, because we don't want to do things like lose our rights to appeal. Interest also accrues. It can be pretty heavy interest. It follows the federal interest rates and usually lies somewhere around a 10% interest rate, as well as a referral to the Department of Treasury. Something interesting about the Department of Treasury referrals, that power actually only lies with traditional Medicare. The Medicare Advantage plans can actually do that, which is why we actually see the Medicare Advantage plans engaging more in this double damages litigation. And that's where a lot of these issues have come up, and why conditional payments have had this sort of resurgence when we're talking about Medicare Advantage plans specifically. And of course, settlement language, because there's this priority right of recovery, there's addition of the double damages, we really want to make sure that as part of our settlement, we're handling conditional payments, we're looking at who's going to be reimbursing the conditional payments, and just making sure we understand how that process is going to move forward.
And Kayla, I wanted to just jump in for a second here too. The double damages, right, that you covered, really, we haven't seen traditional Medicare act in that fashion probably since 2008, 2009. They really do rely on the Department of Treasury, which Kayla just talked about. That is kind of their big stick, right? They can do these offsets. They can really kind of catch people's attention and get their money back by recouping it. And the Medicare Advantage plans don't have that. But one other area I wanted to talk about is there has been a series of plaintiffs' firms and plaintiffs' attorneys in liability claims not resolving the conditional payment. So Kayla just said, right, like don't put language in that just relies on the beneficiary's attorney to reimburse. And the reason why we recommend that is really everybody's sort of jointly and severally liable when you look at this provision of the federal regulations. But we've also seen if you do that, particularly in liability settlements, and the plaintiff and plaintiff's attorney does not repay Medicare, we've seen Medicare wield the False Claims Act through the Department of Justice against these firms, primarily in New England, and then a little bit in the Southwest in like Texas. So if you handle liability claims or you have friends who handle liability claims, we have seen that happen. Medicare can't really go after that beneficiary for that, but we do see them wielding a heavy stick at plaintiffs' firms who just kind of skirt what they're supposed to be doing here. So just wanted to add that as well. I'll turn it back over to you, Kayla.
Yeah, thank you, Annie. And just to add to that too, I would say, if you're ever having an issue where you're trying to make sure that the conditional payments are going to be handled appropriately in the settlement, and you're having issues with cooperation from plaintiff attorney, that line of cases is always an excellent thing to bring up as well. It's not just the carrier or, claimant who could potentially have these double damages brought against them or these types of litigation actions, but also the claimant attorney as well. So switching gears a little bit, we're just going to talk briefly about what the different types of conditional payment correspondence look like. Conditional payments range from the non-time sensitive to the extremely time sensitive. If we're talking about conditional payment letters, very often referred to as a CPL, those are non-time sensitive. We love conditional payment letters because what they do is they allow us to understand the exposure to conditional payments, review our file. They give you as much time in the world to review and decide if those conditional payments are related. And these are really a product of when we're doing proactive conditional payment searches, just trying to figure out what exposure is out there. If we start to move into the time sensitivity area, that's when we're looking at conditional payment notices, or the CPN. This is when we start seeing deadlines. So a conditional payment notice, you only have 30 days to respond to these. So as you can imagine, 30 days to try to look at everything, that's a pretty tight deadline. But it's important to try to meet these deadlines for a lot of reasons. One, it's considered an informal dispute. We're not up into the appeals levels that Medicare has, which we'll talk about in a second. So you don't necessarily need to require things like supporting documentation. So it's a really good way to get that conditional payment sort of resolved in an earlier stage without needing to do as much work to do that. Once we start moving into the demand is when we start needing to add things like supporting documentation, and when we start seeing other things come up like interest. So interest will start to accrue 60 days from the date of that demand. And then there's a second deadline involved with the demand. So 120 days from the date of the demand is our appeal deadline. So the interest that will start to accrue at that 60 days will accrue regardless of if you sent the appeal, but if you're successful, it will get wiped out. That 120-day deadline is super important for us to try to hit, because once we hit that 120-day deadline, Medicare, as a general matter, is going to say, you're done. We're not going to move up into the appeal stat levels after that. There are some exceptions to that, and we can certainly help you out if you're in one of those scenarios, but that's the general rule. The intent to refer letter, or ITR, this is a letter that I like to tell people, don't panic. It's a letter that can make people panic because it's saying, you know, this debt might go to the Department of Treasury, which has all sorts of other things that come with it. But it's a letter that actually is issued automatically. So usually the timing's varied over the years. Back in the day, a lot of times this letter would come in around 60 days, which was great because it was like a secondary reminder. If you were having mailing issues, anything like that, you'd get a second reminder at that 60 days that, hey, have you done anything with this yet? Now, unfortunately, we're seeing these letters get issued more around that 120-day mark. And because of mailing and other things, sometimes our appeal deadlines have already gone. But keep in mind that this letter is automatic. So you might have appeal underway. You might have issued a payment already. Medicare doesn't process payments super quickly. So it really is a time to just level set, see what needs to be done. And then lastly, your Treasury letters. These letters, unfortunately, it's not something you get super promptly when something arrives at the Treasury. Usually it's going to be long after that debt has been with the Treasury. And unfortunately, sometimes don't have a lot of information. So sometimes they require additional research to understand where this debt is even coming from.
Yeah, and Kayla, you'll talk about offsets later on, and sometimes all the notice is getting an offset. The client will get something that just, you know, is electronic, very mumbly-jumbly, and it takes a bit to decipher. So that's a really good point. The Treasury letter, you may or may not get it. Don't panic. You know, give Kayla a call. This is something we can absolutely help you with. There are options, and we'll talk about those here throughout the presentation. The ITR letter too, I call it kind of a screamy letter. There's a reason why it kind of induces panic, because it's in all caps and it's bold, and you're just like, oh my gosh, what's going on? But again, like Kayla said, don't panic. You probably have time to file the appeal. Maybe you already filed it. Yeah, don't freak out. So with that, that's part of our level set. We're going to kind of continue in that vein. We will get to scenarios, I promise you, but we're going to talk about Medicare's recovery contractors first, because this is important when you're dealing with various scenarios in the conditional payment realm. So the first entity I want to talk about is the Commercial Repayment Center, or the CRC. We do love our acronyms in the Medicare Secondary Payer space, so this is one of them. As of October of 2015, Medicare went to having 2 different recovery contractors. And this was a huge shift that caught a lot of folks off guard, even though it had been announced. And if you were handling claims prior to that, And gosh, if you've been doing this a long time, you saw a lot of different things happen. There were regional contractors across the country that you might call. Meridian was one. There were all sorts of just different ways of handling things when you were resolving conditional payments across the country before really the modern times. Then the BCRC was on the scene, and Kayla will talk about that in a second. But the CRC comes into existence in October of 2015 with the sole responsibility of recovering on claims that are admitted, where there's ongoing responsibility for medicals or ORM. So this is your work comp and no-fault claims typically. Rarely is a liability claim admitted, but sure, if you had ongoing responsibility for medical, you could see a liability claim in here. That means that the debtor, usually that they identify, is the carrier or the self-insured, whoever that responsible reporting entity is. This is where they are using your Section 111 mandatory insurer reporting data to figure out who to go after, who the identified debtor is, and to collect. So that's our pro tip. It's triggered by Section 111 reporting, so it really matters that you use the most accurate ICD-10 code or codes. You want to use the fewest amount of codes possible. You have 19 slots. You do not want to fill them all if you don't have to. And you want to be as specific as possible. So if that person has an underlying, shoulder arthritis and they have a sprain strain injury with you, guess what? You probably don't want to put in the ICD-10 code that's associated with shoulder pain, because that's going to pick up even the arthritis treatment. You're going to want to go with the ICD-10 code that really reflects right shoulder strain sprain, and you can get that specific. They want to make sure that the mailing information that you have in your system is up to date. That's what they're going to use to kick out notices and those demands like Kayla talked about. And we've certainly had situations where something gets changed and the mailing address doesn't get updated, so you're not getting your notices timely. We also strongly encourage, to the extent you can do it or you're working with a vendor like us, doing the go paperless feature. Setting that designation in your reporting so that you get all of your conditional payment letters and notices and the ITRs delivered directly to you paperlessly, electronically, online. You want to make sure that you're timely terminating ORM when you can, and that you're reporting your TPOCs, that's the total payment obligation to the claimant, or your settlement amount, settlement, judgment, or award. You want to make sure that you're timely reporting those items, because that feeds over to Medicare as well and will determine whether or not they kick out correspondence at the CRC level, or maybe it's something that they push off to the other contractor. So just in terms of the overview here, the scope of recovery we're talking about is usually pre-settlement recovery actions for work comp and no-fault claims that are open. ORM is, yes, you've admitted the injury. Who are they seeking recovery from? They're seeking it from the RRE, which we've talked about. A letter of authority is required for third parties to conduct conditional payment work on behalf of that RRE. So if you work with us already, we likely already have your LOA on file, and we use it each time that we go and file a dispute or appeal. Kayla oversees the work of our entire conditional payment team, and they do a phenomenal job here of achieving wonderful savings for our clients. Better than 90% of what gets listed on these payment summary forms or the demands is not related to your claimed injury. Medicare uses a grouper or an algorithm. They take your ICD-10 code and they sort of feed it into their system, and that algorithm isn't great. So it captures a lot of stuff that's unrelated. So you definitely want to make sure that you are disputing and appealing, because chances are you probably don't owe most of the money that's listed. We consider this sort of be rolling recovery or continuous recovery. Medicare's contractor, the CRC here, is going through and checking periodically to see if they've made inadvertent payments related to the claimed injury. So they really want to coordinate benefits, and ideally they would like to catch it if, say the person that they're treating with is their primary care physician for everything else. That primary care physician, their office just might bill it to Medicare because that's what they always do. Medicare wants to take your data and send that like a rejection notice back to the office and say, no, this shouldn't be paid for here. It should be paid for under the comp claim. But if that doesn't happen, as Kayla already talked about, right, conditional payments happen for various reasons. especially if you're disputing something, right? You may not be the one who should be paying it right now because you're fighting the good fight. Medicare does need to step in and make those payments. The CRC is the one on a rolling basis. It's going to check periodically and come knock on your door and try to just get those balances cleaned up over time. Once ORM terminates, and or you have your TPOC, right? You close out the file on a full, final, and complete basis with a full settlement. Then Medicare, the Commercial Repayment Center, wouldn't be looking to collect for you for anything that postdates that ORM termination and the TPOC. Kayla, did I miss anything here that you want to add?
No, I mean, I think that pretty much covers it. I would just re-stress again, your Section 11 reporting affects so much this recovery that happens with the Commercial Repayment Center. And it's, just really important that we're being specific in what we're reporting and staying on top of that.
Awesome. Do you want to talk about the BCRC?
Yeah, absolutely. Absolutely. Thank you. So the Benefits Coordination Recovery Center, also known as the BCRC, right? So there was a period in time, as Annie was saying, where the BCRC was the only contractor that existed. And when we think about the BCRC, really at the heart of it, it's ORM, no recovery. So whether we are trying to do proactive conditional payment searches for denied claims, or if we are looking at trying to see what the quote unquote final demand will be for settled claims, whether that's liability or workers' compensation claims, then that is going to be happening with the Benefits Coordination and Recovery Center. Interesting with the BCRC is that we're talking about a switch of the debtor. So they're going to default the debtor to the beneficiary at that point in time, which also changes the authorizations that are in play. So if we're talking about dealing with a conditional payment letter with the BCRC, in order for us to get a copy of that letter, review it, actually determine if it's related to the claim, we need that authorization signed by the beneficiary in order to conduct that work. Something important to note too, and I think it's something that there's also often a misunderstanding around, is just because we had a $0 letter pre-settlement with the Commercial Repayment Center, that's no guarantee that there's not going to be a final demand coming from the BCRC. It certainly is a good indicator. Maybe there won't be any sort of lien happening at the final demand, but these are two different contractors. They're looking at different things when they're looking at, that final lien for the BCRC. Another indicator, just an interesting scenario we sometimes see is, unfortunately, you may have disputed something with the CRC and it crops up on that final demand with the BCRC, right? So you did that pre-settlement work and now it's cropped up again with the final demand. Sometimes I've seen situations where that conditional payment letter was the exact same amount with the CRC, and now we're receiving it with the BCRC. What's great about that, though, is if we've already looked at those conditional payments, we saw those were clearly had nothing to do with our settlement, and now we're seeing that the amount is exactly the same with what we're getting with the BCRC. That might be an indicator that it's going to be worth the effort to try to get that proof of representation form, actually get that conditional payment letter, and file that appeal, since we're unable to know that without having that authorization. But that's just a fun indicator as far as we've actually have a pretty good understanding and likelihood of knowing what is in that final demand. So like I said, often this recovery is considered a final demand recovery. So it's that final sweep. They're not going to issue ongoing demands. And the BCRC, or Medicare as a whole rather, have 3 years from the time that TPOC is submitted to pursue that final demand. So this is where timely reporting becomes really important, not only from the civil money penalty standpoint that I'm sure you've heard us talk about in other webinars, but also just from the standpoint of we want to get these final demands resolved. We don't want to wait 3 years after a settlement to get a lien and have to look at that and see what's going on at that point in time. And likely, if the settlement's being paid out, beneficiary claimant, they're not going to have any money left to pay out of the settlement to resolve that final demand, if that's what we're looking at. So really proactively getting the final demand at the time of settlement is something we really stress here. Yeah. Annie, anything to add generally about the BCRC?
Yeah, I think one other thing I would just note around that $0 letter, Prior to the PAID Act, which we'll talk about here in a little bit, a $0 letter coming from the BCRC on a claim that you fully denied in work comp or was just a liability claim, that was often a key indicator that the person was on a Medicare Advantage plan too. So that's what a $0 letter could also mean, is that there's no balance with traditional Medicare because they're not on traditional Medicare. And Kayla and I will talk about that because it's a whole different ballgame when you're dealing with a Medicare Advantage plan. So that's the only other little nuance that I would add about a $0 letter. But you never want to run with that and assume that that is what it is, because that 3-year statute of limitations is out there, and that final sweep should be done. So awesome. We'll move into disputes and appeals now. There is a 5-level appeal process. So you already heard Kayla talk about, right, with the correspondence, you heard her talk about this idea of an informal dispute. So conditional payment letters, conditional payment notices, those do not trigger the formal appeal process. If you wanted to dispute anything that is on either one of those, you can file an informal dispute. We're happy to do that for you. Like I said, Kayla's team does this all day, every day, and we're pretty gosh darn good at it. But it's really that demand is what triggers the formal appeal rights process. So you really want to perk up when you get a demand and it says on there, you have 60 days to make a payment or interest will accrue, right? 120 days to appeal, like Kayla talked about. What that is that's just a redetermination, is what we call it. You go back to Medicare's approved contractor. So the BCRC or the CRC, whichever sent it in, you go back to them for that level 1 redetermination appeal and you ask them to reconsider. You say, hey, look, I don't think you have everything you needed to know. This is all unrelated. Your grouper is, your algorithm is bad, whatever it is, you're going to go back. You do typically want to have the medical records to prove it. Like Kayla said, you might not have that when you go for the informal disputes, but it's best to have it in hand if you can get it when you're doing any sort of formal appeal. So that gets looked at by the same contractor who made the decision originally, and most of our cases are resolved at the level 1 and level 2 appeals process. So level 2 is a qualified independent contractor. This is considered reconsideration. So if you're not happy with the decision you get for redetermination, it's 180 days, you get to go back and file a reconsideration request with a qualified independent contractor. For those of you who might handle California claims, you might recognize one of them is Maximus, the other is C2C Innovative Services, and you file with whichever one the jurisdiction happens to be covered by. And this gets a little bit more formal. You definitely want to have as much in terms of the records as possible, or whatever you're pushing back on, right? Maybe you paid for it, or it's a provider who wasn't authorized. You want to have everything that you need at that level if possible, because they're an outside entity. They're not affiliated with the BCRC or the CRC. They're supposed to be giving it a full kind of de novo review, looking at it and seeing what they can make of it. And then if you're not happy at the reconsideration level, you have time. It's only 60 days to file for an ALJ appeal, and then another 60 days for Medicare Appeals Council, and then level 5, you're heading into U.S. District Court judicial review. Those level 4, level 5 are extremely rare. ALJs are pretty rare too. I used to handle these in my past life. We can certainly help you with those here. Thankfully, the level 1 and level 2 appeals seem to sort it out. And then we do have escalation contacts at both of the recovery contractors that we tend to use before we have to file at an ALJ level. But it's super useful because when you hit ALJ, you're talking to somebody who has maybe more of a level head, is more reasonable, isn't so stuck in their ways, and kind of has tunnel vision. So you can really get those arguments in front of the judge and have a cooler head prevail if you're seeing that the contractors are really struggling understanding the concepts that you're putting in front of them. So just want to make you aware of that appeals process. It's really unfortunate that we have to use it as heavily as we do, but it's wonderful that we have it, because here's where we have that note about the grouper algorithm. It consistently includes services that are unrelated. So we do use that. That's the LOA that Kayla talked about, or the beneficiary proof of representation, that BPOR. That's what it allows us to go ahead and file those disputes, or excuse me, those appeals, and have them considered. We do use them for disputes as well. So what kind of arguments do we use? So you'll see some of these in our examples coming up for the scenarios, but we wanted to just make sure that you kind of think about all of the dispute and appeal arguments available to you. We talked about a big one, which is the care isn't related, but there's others. So if you handle no-fault claims, the policy limit has been exhausted. Sometimes liability has that as well. If you've dispersed the maximum policy coverage, there is no more money. That is an absolute, real basis to appeal or dispute on. Total settlement amount, especially on those denied claims, Medicare's recovery is capped at the total settlement amount. They can't be demanding more than what the parties settled for. Unauthorized treater or provider, you already heard me mention that. If you're in a state that kind of really outlines your ability to direct care and they're treating with someone else, you can go ahead and dispute and appeal on that. Statute of limitations. There's a 3-year statute of limitations where Medicare, from the date that Medicare, finds out about the settlement or that ORM termination. And so you really want to keep an eye on that. If they're trying to recover for care that happened more than 3 years ago, we want to fight that. And then duplicate payment. Maybe you already issued payment to the provider and the provider also, billed Medicare. That's also a reason to dispute or appeal. Kayla, what are you seeing in terms of overall trends?
Yeah. So, the trends for conditional payment disputes and appeals really vary year to year. And there's also ones that we see repeat patterns on. Currently, we're seeing kind of a repeat pattern happening with the CRC where they are actually ignoring those first informal disputes. And this is something that traditionally we've seen happen at times when maybe their contract was coming up for review, maybe they're pushing for more revenue at that time or recovery coming in at that time. Usually there's some sort of outside pressure happening when we're seeing this happening. And this is across, all carriers, all people doing this type of work. We start seeing that those disputes being ignored. And we're able to tell that through a couple reasons. One, if we're calling and escalating, they're telling us, actually, this wasn't reviewed. Sometimes we're actually seeing that that correspondence is still open in the portal and they've already issued a demand, a clear indicator that they did not review that dispute. So this is possibly due to outside pressure, possibly due to capacity issues. We're not sure, but it is a trend we're seeing right now. I'd say a lot of the trends we're seeing in other areas really have more to do with the no-fault disputes and appeals. This is something it's not necessarily new, but we continue to see high scrutiny on situations where policy limits are exhausting. This is an argument that for whatever reason, Medicare has never loved. They do not like to agree with these appeals. They require lots of documentation and they keep upping the ante as far as what they want. Most recently, some of the things that they've been cracking down on in this area are in your actual payment ledgers that you're submitting to Medicare. They want to see not only how much you paid, but how much the bill was for. And this can be an issue. Medicare doesn't necessarily consider your claim systems. A lot of claim systems have been pre-set up for you to pull this information in an easy, digestible way, whether it's in Excel, whatever it is. So that information simply isn't in there. And sometimes we're having to backfill it in other ways. So this is an interesting thing that we've been seeing and a reason they're trying to kick back on policy exhaust arguments. They're also continuing that higher scrutiny on the timing of payments. So, a lot of policies for no fault have the ability to pay out the policy limits to that beneficiary or their attorney. And sometimes in certain jurisdictions, there's some level of requirement to do that if demanded. Medicare is going to look extremely closely at those transactions. They want to see things like the bills that were submitted. They're going to look at the time the payment was issued. They're also actually going to ask pretty standardly now to see your policy and where in your policy it says you're even allowed to do that. And there's some, to an extent, there's only so much control we can have over this. But definitely recommend trying to make sure and see if Medicare has made payments. Certainly, we've seen some scenarios where, payment was issued for bills that were submitted by the beneficiary where it actually does show that the payments were paid. or the services were paid for by Medicare. So when Medicare came calling and was asking for those bills that were submitted, they're saying, hey, you definitely had a reason to know that Medicare paid for these bills. And that is something that is actually outlined in the statute as far as Medicare saying, if you know or have reason to know that we've made a payment, our repayment takes priority. So that's definitely an area we see a lot of people struggle, and we're happy to assist in any way we can in getting those disputes and appeals through. And then lastly, one of the things we see or have been seeing most recently is a ramp up of conditional payment notices, again, in the no fault space. You know, we always go through different seasons of the recovery contractors doing different types of things, focusing in certain areas, maybe pushing out certain types of letters in certain areas. I know that there has been some projects around dealing with the grouper algorithm when it comes to no fault claims specifically. We haven't seen any changes necessarily in what these liens look like, but it is possible that that is part of the reason we're seeing this higher level of letters. But generally, as far as workers' compensation insurance, liability insurance, those disputes and appeals really have stayed pretty much status quo, I would say. Do you have anything to add with that, Annie? I'm
No,
not sure.
I think you covered it. Yeah. Well, yeah. Sorry about that. I muted myself.
Oh,
So no, I think we're good there. I do want to move on to the scenarios. We do have a couple slides in here about the fixed percentage option, so we will make the slides available. There are some self-service options that we wanted to make sure to include. Fixed percentage is one, and waiver of recovery is another. Fixed percentage option you can use in the liability realm, so please take a look at it. It's for settlements that are $10,000 or less. You may be, the claimant or the plaintiff may be able to just pay a flat amount to reimburse Medicare regardless of what Medicare paid. And then waiver requests are used post-settlement typically to ask Medicare to waive the balance for whatever reason. Usually it's going to be a hardship waiver or something like that. So there are a lot of tools available in this space. But we wanted to touch on these routine and rare scenarios, and then we'll kind of keep trucking along here. Kayla talked about hitting that 30-day deadline to dispute. What happens if that has passed? What do you do now? Well, the sky isn't falling. It's usually an indicator that about 30 to 45 days after you get that letter, you're probably going to get a demand. So if you're not able to dispute that really early into that 30-day deadline and you're kind of coming up against maybe the 30th day, it's likely that they already have a demand, rushing about and on its way out to you. So Kayla was talking a little bit about that, right? She's seeing the recovery contractor not even work some of these disputes. And we think part of it is the outside pressures. Part of it could just be, right, if you filed on the 30th day, they're already moving on. So that's very routine. Don't stress out about it. Unrelated care due to the wrong ICD code listed. So you reported the wrong code on accident, right? Or your TPA did. What do? Pretty routine. Medicare doesn't get to collect from you just because the wrong code got put in, but this does take a little bit more sophistication. It requires going back to the contractor, showing them that you've changed your Section 111, letting them know if it's already been sent via an off-cycle report, or it will be sent at the next quarterly reporting deadline. So you kind of have to work your appeal hand in hand with kind of fixing the Section 111. You do still have to resolve conditional payment claims on a claim where you have an approved zero allocation. Just because there's no money being allocated for future care doesn't mean the parties aren't jointly and severally liable for resolving the conditional payments. Medicare really takes the position you should have tried the case in one if you wanted to have to pay nothing. Now, rare, what do we see that's kind of rare? Why would you see the BCRC maybe attempting to recover against a carrier? Like, Kayla, Annie, you just told me that the CRC would come to me if I'm a carrier or self-insured. Well, it could be a situation where the case originated prior to 2015. If that case originated prior to 2015 and has been hanging out there, the BCRC still maintains jurisdiction over it. So it's rare, and it's, as each year goes by, there's fewer and fewer cases that the BCRC maintains. If the BCRC is trying to collect a no-fault balance on a non-existent claim, this comes back to Kayla and I are working on a case like this right now, where unfortunately a TPA reported information on a claim that didn't belong to this particular RRE. It belonged to another one of their RREs. So we right now are working with the BCRC to do some research, go back, find it, get it re-reported wrong, get it then deleted. That is rare, but again, it's going to take more finesse and working with someone like Kayla and her team here on getting that sort of, resolved. The CRC won't remove unrelated charges due to an untimely filing of appeal. I've had this happen before, where they sort of dig in their heels, and the reconsideration contractor, even, right, the QIC, basically takes this position. I've taken these cases to ALJ. I've gotten right in front of the judge, and I'm like, look, it doesn't matter that this wasn't timely. All of these charges are not related. My client is not the primary payer for these. You can't take this money. That there's nothing in the regs that allows you to take money that isn't owed, despite the fact that, a deadline wasn't followed. The recourse for something like that, if there were, an issue with reporting timely or something, that goes under like civil money penalties, right? That doesn't fall here. So be very aggressive about that. Get that over to us. We'll absolutely help you with it because it's inappropriate for Medicare to try to recover for money that they didn't that they aren't owed under any circumstances. One other case that I wanted to bring up too is what happens. This is pretty routine. Plaintiffs will jump the gun and their attorneys will report that the claim is settled when you haven't yet reached settlement, and so you will end up with a demand before settlement has occurred. What do you do in that instance? That is an instance where we want to get on the horn with the contractor and let them know that the case isn't settled. We basically want them to rescind the demand. Maybe the parties are okay with it and you want to move forward with it, but misrepresenting that a case is settled isn't great. And that behavior is not looked upon favorably when plaintiff's attorneys do it. So those are our kind of routine to rare scenarios. We want to keep moving along to the Department of Treasury. Why do debts end up at the Department of Treasury? Really, there's been no response or an improper response, or sometimes even a proper response, and it still gets forwarded to Treasury. What do you do then? Kayla, what are the options that one has once the debt is with Department of Treasury?
Yeah, so thank you, Annie. Really, what road we're taking when we're dealing with Department of Treasury stuff requires not just a prospective plan, but really a retrospective look at what's been done on the file, right? Whenever we're looking at something with the Department of Treasury, we need to take stock of what's been done on the case to date. And I like to think of this as two different roads. I have my green car and my red car. The green car is we've hit all our deadlines appropriately. We've been following our appropriate path through, filing our dispute, filing our appeal, moving up through the appeals process. And when we're talking about that situation, there's just generally less roadblocks to getting that claim resolved favorably for us. If we're talking about missed deadlines, then it's not a hard stop. It doesn't mean we do not have recourse, like Annie said. ALJ in particular can be more amenable to listening to those types of arguments and agreeing with them, but it does just create this additional roadblock, and we might have some other considerations to take into consideration. And it might require outside escalations. Medicare also has these exceptions for good cause. The exceptions for good cause for having missed an appeal deadline is really narrow. However, it's really limited to natural disasters. We do get creative in how we make that argument and are able to get things through in an easier way that fashion, but it does require just that creative thinking when we're talking about our deadlines have been missed. How are we going to get Medicare or that contractor or that escalation contact to see that this is really not owed? And unfortunately, some of these liens, if they were unaddressed, sometimes I've seen, $40,000 plus of very clearly unrelated treatment, has absolutely nothing to do with the claim. And of course, we don't want to be making payment for that. So the other question is, what's our path to appeal? What's the right direction to take? And then do we issue a payment? Because if something's with the Department of Treasury, it's accruing interest. Particularly with the Department of Treasury, they look at interest on a daily accrual as well. So it's a moving target with them as well as far as how much they're thinking it's owed. They can also offset you at any time. So there's really a conversation on your own risk tolerance. Do you feel like you want to make a payment? And when we do make these types of payments and we're appealing, we call that a payment under protest. We want to be very clear that that's what we're doing. We're not giving up our appeal rights. But I think both myself and Annie, feel similarly on this, in that we do not want to issue a payment. We don't want to issue a payment if we think that that money isn't owed. But of course, there are some other logistics to think about when we're talking about whether or not we're going to make that payment. And it's arguable. I think we both might say that if you issue that payment, now they have your money. They don't want to give it back. They don't want to process a refund based on that appeal, especially if we're talking about deadlines having been initially missed. So ideally, we're going to move through that appeal process. But like I said, it's really a case-by-case basis when we're looking at the merits of the claim. How good is our argument that this is unrelated? And then making those decisions about whether or not we think a payment should be issued.
Absolutely. Thank you, Kayla. With that, we're going to kind of jump ahead. We have some more slides in here that you can take a look at your leisure about Treasury offsets, what that looks like, the timing of those offsets, and programs that will help you avoid those offsets. And we have some specifics in here for the G2G program and the open debt reports, and then how to prevent those referrals to the Department of Treasury, meet those deadlines, ensure that accuracy. Some of that stuff we've already talked about. In terms of routine to rare scenarios here, routine, you'll see them maybe sometimes trying to go after a claimant's estate. Good luck. Formal estates are not required in all states. Do you make that payment to resolve the Treasury debt or not? And if you do you pay the contractors or do you pay the Treasury Department? By and large, it's usually paying the contractor. The Treasury Department will lose stuff very easily, and they don't track stuff very well. But Kayla talked about that. Do you make a payment under protest to stop the interest accrual? That's pretty routine. And it's easier to do with the contractors than at the Department of Treasury. Rare scenarios, you'll see entities in the same small town using the same tax ID number. So the police department didn't take care of their work comp claim, and now the funds are coming in from the federal government for the school district, and Medicare takes some of those funds automatically through the offset program. Pretty rare, but you see it. So you want to make sure that if you're sharing a tax ID number in a small municipality between the police department and the school district and other entities, that those conditional payments are being taken care of. And then unresolved Department of Treasury cases could also result in the government stopping an entity's ability to contract with them. So if you do federal contracting with the government, you don't want to have a case at the Treasury Department. So with that, we're going to jump into Medicare Advantage plans. Again, we've got slides in here kind of for background, but this is Part C and D. Kayla already talked about it, right? 54% of Medicare beneficiaries are enrolled in these Advantage plans. And so you want to be aware of how, if they're out there. The PAID Act will tell you that. Using the query response information will tell you what plans they're on for the most recent 3 years. It's not always accurate, but it gives you a place to start. What makes handling these different is that we're looking at double damages. That's what Kayla talked about, right? They don't have access to the Department of Treasury. There's no portal. There's not one entity you're dealing with. This is every subrogation company or their agents that you're dealing with. It's very different, and the processes change a lot. The behaviors change a lot. Like Kayla talked about that, right? A little bit that we see some interesting things happening, not only with traditional Medicare, but with Medicare Advantage plans. They sue for double damages. We have rulings in these states. The colors don't matter so much, but just because a state is gray doesn't mean you don't do anything. In fact, you do something, and the Advantage plans are doing things. They want to get their money back in these states, and every state that gets a ruling finds that double damages are available. So Kayla, do you want to talk a little bit particularly about the behavior you're seeing with some of these Medicare Advantage plans? I know we're coming up on time, maybe about 4 or 5 minutes left, but let's talk about what you're seeing here with these scenarios.
Yeah. So I'll try to hone in on a couple of the ones that I think I find the most pressing or the most, interesting. Again, to Annie's point, there's many Medicare Advantage plans, and not only that, but they're also utilizing these subrogation companies. And we think about these subrogation companies, they're not experts on Medicare recovery. They're not even experts necessarily when we're talking about workers' compensation, liability insurance, and how that all works, which means they push a lot of boundaries to try to do the recovery. And it does require a lot of pushback from us to try to keep them to what we would consider their actual rights when it comes to these conditional payments recoveries. Some of the things that we've seen are, at the very beginning, Annie talked about that recovery threshold. For whatever reason, somehow these Medicare Advantage plans or their subrogation companies find out about settlements that happened under threshold, and they're saying they're trying to get recovery on those claims, and we have to say no, there's no recovery right here. We also see situations where actually no settlement's happening at all. Maybe that liability claim never came to fruition, no one ever filed suit, statute of limitations have run, there will actually never be a settlement in that scenario. They believe that they are still entitled to recover for conditional payments in those scenarios. We've seen arguments about stepping into the shoes of the claimant in that scenario. One of the most concerning ones that I have seen, and I think Annie may have some comments on this as well, is actually rearranging of the payment summary form. We've actually been able to see that some of the subrogation companies, because when we're typically looking at a conditional payment and what was paid, sometimes we see, or we go by whatever that initial main ICD code is, right? Because doctors will throw in all of the underlying conditions, but that's not truly what the treatment was for. So we typically looking at what those main ICD codes are. We're actually finding we're looking at a bill, and then we're looking at what the Medicare Advantage plan has submitted, and they've rearranged them to align with what the injury is. We've actually even seen this happen after we've disputed a charge. So there's definitely some maybe bad faith dealings happening within that, but it's something we have seen, it's something we've heard others talk about within the industry, and it's definitely something to keep on the radar. Annie, did you have something you wanted to add in regards to that?
Yeah, I think as we kind of just come up on our last couple minutes here, query whether there's a reason why maybe the largest health insurer in the country is possibly facing a criminal investigation with regards to how they handle their Medicare Advantage plans. You do see this behavior, like Kayla said, it's not right, and it goes hand in hand with other behavior like upcoding and things like that the Department of Justice are investigating. So if we didn't get to your question here today, thank you so much for asking it. We will email you afterwards to let you know. But we got through our scenarios. We had a couple more in here that were rare. We're taking a break for June, so you get June off from our webinar series. We'll be back in July. Watch for that announcement. If you want to be pre-registered, email us at spotlight@sandersoncomp.com. We'll get you pre-registered for July and all the other future ones. Our services are listed here for you, and then some more information. You've heard us probably talk about MSP College. We have those slides in here if you're at all interested in getting certified in either of those certifications. With that, we thank you so much for your attention today. Please don't forget to fill out the little survey that we have at the end. And my contact information is here. Kayla's contact information is here. We really appreciate the time you took to spend with us, and we'll get those questions answered if you had any. Thank you so much.
Thank you, everyone.